of intellectual property. Under this umbrella, there are around 7 different things. The first one being the patent, the second is the trademark, the third is the design, fourth being the copyright, fifth, the trade secret, sixth, the geographical indication, and the seventh, plant variety protection. The seventh one has been newly added. Since it is, I believe the audience here is a general audience, so I will try to be open so that I can, talk something about biological science as well as other sciences apart from engineering science. So the first one is the trademark. Well, tick of Nike, F of Facebook, or the M sign of McDonald's. These are these are all what we call as trademarks. This means that this M has been registered by a company known as McDonald's, and no other person or no other company can use the same logo for themselves. Next is the industrial design, whether it is the shape of a Coca-Cola bottle or whether it is the shape of iPad, the design of iPad or iPhone. These come under industrial designs. Design basically how it looks like. When we talk about the working of iPad, then it will come under a different version that we'll speak about patents today. The third is the copyright sector. I mentioned specifically within India here, uh, because other than India, if you talk about United States, software and computer games need not necessarily come under copyright section. Copyright is your literary work. If you have written a poem, if you have written, if you have made a movie, if you have taken a picture, or you have written a program, a software program, this all comes under copyright within India. However, we have to keep here in mind that generally we put a C and a round around it and say that this is copyrighted so that nobody copies it. In case we need to tomorrow prove that this has been written by me, for example, if I wrote a computer program and I see that somebody else has taken this program and somebody else is using this program and I see it is copyrighted, I need to necessarily register this program, my software, with a company, which in this case is Intellectual Property Rights of India. That's the copyright section, which has several offices, one being in Delhi as well. Then is the trade secrets. Famously, we have Coca-Cola's trade secret. We don't know how Coca-Cola has been made or what are the spices put in KFC, that is Kentucky Fried Chicken, how Listerine is made. Um, we don't know how the search algorithm of Google works. So these all come under what we call as trade secrets. The next is the geographical indication or GI. It is used for specific products which have a specific origin. They have a specific quality, they have a specific reputation, and it belongs to a specific place itself. Like the first example I have given here, you can see it's a sari. And when you see something like this, a good design, obviously it comes to our mind is Banarasi sari. Okay. Likewise, there are some geographical indications within, Kashmir as well. GI given to saffron recently, a saffron produced in Kashmir, means that nobody else can sell this saffron other than from the one which has been produced in the Kashmir as a Kashmiri saffron. Likewise, the Kanishal I have mentioned here. I have given an example here of Shirma, like we see the one from Pampur or adjacent areas. Uh, this can be made as a geographical indication in which the Shirmal basically has origin from that place. And there is one here, in which there are barbecue sticks, and we know one popular which is from Khayam. So so that somebody does not copy the kanishal from anywhere other than the Kashmir, and somebody does not sell his or her shawl which is not based on the origin of Kashmir. So this gives a protection to the product based on a geographical origin. It's not for a specific person. It's not for a specific company. It's for a specific place. And the last one that we have, which has been recently added to it, recent in the sense that it's been a 20-year-old addition. It's recent as compared to the other intellectual properties rights that we have. And it's known as Protection of Plant Variety and Farmers Right Act, PPVFR Act, in which intellectual property rights are given to plant breeders, researchers, and farmers who have developed any new or extant plant varieties. Okay, this was about the umbrella of the IPR. Now, the next slide I have put here is the value of global brands. This is a bit older slide, 3 years old, but I want to show a comparison here. There are top 10 companies which are given here of 2017, in which we have Google, Apple, Amazon, AT&T, Microsoft, Samsung, Verizon, Walmart, Facebook, and so on. And as the next slide shows the top 20 companies who have produced patents in 2017 itself. And you can see those companies which are top 10 are mostly within the top 20 companies who have produced patents in 2017, like IBM, Samsung, Canon, Intel, LG, Qualcomm, Google, Microsoft, Samsung, Apple, Sony, Amazon, and so on. Well, the comparison here shows that the value of your intellectual property actually is the value of the brand. The more the IPR you have, the more the valuable brand you have, and obviously the more the money you will make. Okay, after this, there is this slide which has some examples being given here. If it would have been an interactive class, I would have asked you to actually one by one name these, uh, like what comes under. So I'll just answer them myself. The first one being the Coca-Cola's can. It is an industrial design. Apple's iPod, the design here is industrial design. Harry Potter, written by J.K. Rowling, the novel, it is a copyright. Then we have the design of an instant camera. It comes under patent. Pashmina shawl, it comes under geographical indication. And then the last one is DNA copying process, which comes under the Plant Variety Act. So before we actually see what can be patented, we have to distinguish between two things. One is the invention, another is the discovery. Invention is something which is new. Discovery is something which is already existing in nature. Invention is a man made process or a device, whereas discovery is to uncover scientific principles which are already existing in nature. Edison invented the light bulb, so we call that as an invention. And Edison gave Edison's effect, which is basically a discovery. Inventions are patentable, and discovery cannot be patentable, because this is something which is already existing in nature, and this is something which has been just uncovered. So what is basically a patent? A patent gives you an exclusive right granted by a government authority. In a case here, we have Intellectual Property Authority of India, offices in Delhi, 4 metros. It gives the exclusive rights to an inventor or an assignee for a limited period of time, that is 20 years, in exchange for detailed public disclosure of an invention. And what are these rights? When we say exclusive rights, Nobody else can make it, nobody else can use it, nobody else can sell it or offer to sell it, or nobody else can import this invention. It is exclusive rights. There are two things within it. One is the negative rights, another is the territorial rights. Negative rights, first one says that no other person can sell it, offer to sell it, or make it or use it. This is the negative. And territorial right is within the territory where this patent has been registered. That means if my patent is registered in United States, okay, nobody in United States can make it, use it, sell it, or offer to sell it, except without my permission. And what is my permission? I sell the licensing of the product that I have made, okay, or I sell the patent itself. Okay, you take it, give me the money, you do whatever you want to do it, or I keep the rights of the patent and I only sell the permission to use it. Then what I would get in return is the royalty of it. So this is basically what a patent is, giving you the rights. It can be for a product and it can be for a process flow of Indian patent. I have a graph of it to basically show how it goes. This looks a bit complex, but for a beginner, the first part here, let me see if I can use a marker here. Oh, I don't think I have that option here, but anyhow, if you see at the top, the first thing that we have here is filing. And what do we have in filing? You have a list of forms that you need to fill. Once you have filled those forms and you have informed the patent authority that this is my idea, this is how I'm going to make, they register it, you pay the fees, and they put it in the patent office journal, which comes online, and everybody would get to know that, okay, this is the idea and this is how it would work. This is known as publication process. Then with some other forms and also some additional fee, you request them to examine and they check, okay, this is your idea. Uh, 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 for example, I'll take an example. Let's say I have a phone here. So my idea is, as an example, a cover of a phone. Okay, this is my invention, that I design it in such a way that I protect a phone by covering it. I have kept certain things within it, a machine, let's say, which charges the phone itself. Now if I only give this as a patent, it might come under a design. Why? I'm designing a cover of a phone. But since I can, make a patent in such a way that I say that within my cover, I put a battery which can be an additional charge for the phone when I'm using it. And also, like we carry charge bank, I don't have a charge bank, I just have a cover I put on it, and this would be a charge bank as well as my phone cover. So two in one. So this can be a simple example of a patent. Now I have given the design of it, I have given the working of it, I have given how it's supposed to charge my phone, what it's supposed to have, and so on. So they publish it. Now somebody from patent office has to see whether the given invention that I'm saying, this cover, is patentable or not. So there are some rules that they will go through. I have that in the next slide. Once they examine, they will reply to you with the report, which is known as first examination report. Once you get that FER, you're supposed to reply. Okay, you reply that, okay, this maybe they have some questions like, Are you sure that it's not hazardous? Are you sure that it will work in conditions? Are you sure that it will not heat up the phone? Are you sure it is patentable? All the questions as per their acts, they would ask you, and you will reply to them. If the patent authority feel that yes, you have replied enough, this is good enough what you have said and it is patentable, they would grant you a patent. If not, you'll be given a chance in which you will be heard by a patent authority, patent attorney, and there would be a judge, and you would have to explain yourself in front of the judge. And if he feels fine, again, you may be granted or you may be refused. Then you need to appeal, then again, High Court and Supreme Court, and so on. I'm just saying, just in case it might prolong. Otherwise, if it's good enough, if it's understandable, if it's doable, you can get the grant easily. There are some things which are mentioned here as pre-grant opposition, post-grant opposition. It's like somebody else feels that no, this was supposed to be my invention, so he or she says that no, he should not be given. Then you have to justify again that how do you say that it is your invention, not the one of the other person, and so on. You might have heard about the cases between Samsung and Apple, okay, in which Samsung had to pay millions of dollars. Why? Because they thought that, they said that this is our invention, but Apple had already registered a patent with regards to that. So Apple said that this is patent infringement. And after hearings and so on, Samsung lost it and Samsung had to pay a huge amount. Anyhow, so the next slide says basically what is patentable. As per the Section 21J of Indian Patents Act 1970, invention is defined as a new product or a process involving an inventive step and capable of industrial application. So, 3 points that we have as a criteria for patentability. The first one is novelty. Okay, it should be something that is new. Okay, or its use should be new. The second is inventiveness, that is non obviousness. It should not be obvious. And the third is its industrial applicability, that it should have an application in industry or utility. And who can apply for a patent? Any person can apply for registering of a patent. He has to be the true and the first inventor of the invention, or he can assign somebody, like I give the rights to somebody that you go and you file the patent on my behalf. Typically, this is done in case you want some patent lawyer to draft a patent application for you, and you give the rights to him and say that he is my representative and he'll be taking care of that. When to file a patent? Okay, you should be the first one to file a patent. Okay, it's not tomorrow, then it's never. It has to be today. Why? Because timing in patent is very important. You never know, whatever idea you had, somebody else also might have the same idea. If he or she files the idea before you, then you lose the rights over it. Even in fact, if two of you have discussed this thing, the other one does it first in his name, you cannot say that it is my patent because the other fellow has registered it before you, even though it might have been your idea. So timely is very important, and then once it publishes, you obviously broadcast it. But before filing, you do not tell this idea to others. Okay, you do not broadcast it to others. You do not inform anybody that this is what I am intending to do. So uh, do not do not tell others, which also means that your idea should not be published in any journal. You should not publish before you actually patent. It should not be somewhere in internet or anywhere written. So the next slide would say about patent application as such. Prepare a patent application means you need to do searching and drafting. That is the first step. Searching and drafting, I have taken a separate slide here, so I'll explain how to search, what to search, and where to search. You have necessary forms, which is form number 1, 2, 3, 5, and 18. You can easily get them on the Indian patent website. You can file them online also, provided you have I believe digital signature might be required for that. You can make online payments as well. These forms can be easily downloaded. Okay. If you need some help regarding these forms, I will put my email at the end of the presentation, and you can feel free to take those forms from me. Otherwise, they are available on the website easily. So, types of applications, we have ordinary, that is provisional or complete, then convention, and then PCT. To begin with, you would have an ordinary application. If at this moment you just have an idea, you do not have the complete product. Okay, like I said, I have an idea in which I have a telephone cover. Okay, I want to make this telephone cover such that it is a chargeable and is always attached to it. So my phone gets discharged, this thing would charge it by itself. How? I would keep something here which is a battery, like a phone bank. Okay, and then maybe the wireless charging in this one and wireless charging in this one, they are together, my phone automatically gets charged. When this thing gets discharged, I take out the cover, I put the cover separately on charge, and things like that. Or when I charge my phone, automatically this thing will also get charged. Okay, in fact, this seems to be a good novel idea, that your cover would be a charger as well. So once you have this idea, but I don't know how to do it yet, but I know what it does. I can file a provisional application in which I would write that my idea says that I would charge a phone with my cover, which would have charging capabilities. Then actually how it does, what all I would require, the design of it, the circuitry of it, it will take some time. So for the time being, I will file a provisional application, and with time, once I'll be given some time, 6 months or 12 months. During that time, I would not necessarily actually make it, I will just design it on paper. Okay, show it's working, show a complete specification of how all it works, and then I will file a complete specification of it. Then this type of application, this ordinary application filed in Patent Office Delhi, would give me the territorial rights within the Republic of India. Beyond that, if if I have to ensure that nobody in United States would use this thing without my permission, then I would have to separately fill a patent application in United States. I can go to WIPO, that is World Intellectual Property Organization, which is in Geneva, and file a PCT application, wherein I will be given around 31 months, during which nobody else within those countries who abide by WIPO convention can copy it or use my invention or make my invention. Here are the details of the forms which I have mentioned here: 1, 2, 3, 5, and 18. Form 1 is the application form, Form 2 is the complete specification. Then you put the drawings, abstract, and so on. Uh, the details are given here. I'll just move to the next one. Then the first step, like, you have an invention, it's in your mind. Now you want to patent it. The first step before actually even filling a form is to search it. How would you search it? You would, s- uh, you know, why would you search it? The first thing is, okay, I gave an idea that my phone cover should charge my phone. Maybe somebody has already done it. I go and file, and the patent office tells me, sorry, before you even actually filed it 1 year back, somebody had patented it. Or somebody else has already mentioned it in a website which is here, or somebody wrote a paper a research paper in which he mentioned that charging can be done wirelessly using a cover and things like that. So they can say, your work is not patentable. So do not reinvent the wheel. What we mean by reinvent, if somebody has done it, you cannot patent it. You waste your money, you waste your time. But what can you do with the wheel is you can modify the wheel. What I mean by modify is, uh, let's take an example of wheel itself. Okay, we say don't reinvent the wheel, but then newer cars have a tubeless wheel, an alloy wheel, and things like that. So modification of wheel can be done, and that can be patented. So start with a basic search. See if somebody has actually worked on this. See what problems did people encounter. What is the state of art? If somebody has given an idea of it, how far has he reached? Okay, has he really been able to do it, in which, what your thought was in mind, that a cover can be the charge bank, a cover would be charging wirelessly the phone. Maybe somebody just said that cover can be the charge bank, but you are saying that a wireless charging between the cover and the phone itself, wireless charging of the cover once you plug in the phone, and all those things combined together, you make your own new invention. But keeping in mind that you checked the internet, you checked available, or databases where you saw that nothing like this has been done. Now, I got an idea wherein I have a cover of phone which I can be of charge, but it has to pass a search. Okay, nobody has done it. In addition to this, I had given three criteria. Not I have given it, basically the Patent Act mentions it, that there are three things: novelty, non-obviousness, and industrial applicability. Okay, novelty, it is new. Nobody has done it because I searched it everywhere. There's no problem. It is not obvious, okay, because cover is for protection, but I am modifying the cover in such a way that it can be used for charging as well. So second point is also done. The third point I have to see is industrial applicability. I make some product. Basically, why do we actually patent something? At the end of the day, we intend to sell it to a company so that you get revenue or royalty out of it. Basically, it comes down to the money. So you would patent something because you would, at the end of the day, want to sell it, you want to make money out of it. So see the third point, whether it is really applicable or not. As a faculty member, if we feel that, I believe most of you are in teaching field, so maybe industrial applicability may be there. If this can score some scholastic points, if it can help in promotions and things like that, so I believe, I mean, you should give it a try. Then maybe you will feel that, okay, tomorrow who would take it, that might stop you from patenting. So I don't think that should be a reason for you to not patent. If it can help you, scholastically, you can get some points out of it, then I would suggest to go ahead with it. Now, moving to the search, there the search specifically has to be firstly from a particular patent database. There are free databases as well as paid databases. Free databases is USPTO, InPass, eSpaceNet, Free Patents Online, Google Patents, Orange Book, and so on. Also, there are paid databases like Derwent Innovation, Thomson Innovation, and so on. Other than the patent databases, you can, uh, maybe you are looking for something in which somebody has not patented it, but somebody has kept the information open in public domain. Like I said, somebody wrote an article in which he gave out the idea of cover being the charger. So that's also not patentable. So other than patent databases, you would have to search for non-patent literature, like Just Google it, okay? Or go to specific sites like, typically I use ACM, Digital Library, IEEE Digital Library, Science Direct, and so on. You can use the similar databases. So these are the steps that you would need to do before drafting a patent application. Firstly, conduct a prior art search, which I just now mentioned and which is very important. Enlist the problem in prior art. Now, if you found that somebody has given out an idea, let's say in an article in which he mentions that, okay, why not to have a charger, charging bank within the uh, uh, within this a cover, okay. uh, so but he doesn't say how it is to be done, and he doesn't actually mention that it's a wireless charger. It doesn't mention that the dimensions are such and so. It doesn't mention that it's so slim that you can just put it there, and um, you don't have the feel of bulkiness and things like that. So with all these things, you can say the problem with the idea that specific person had given is this. It does not take care of this. So you have to make a specific problem statement on which your patent is actually solving it. So with that, you would then have firstly the novelty, something that is new, and you would say that it's not something which was obvious. Why? Because the idea that was given there did not say these things. And then the third is because everybody has a mobile phone nowadays. Everybody faces a problem of charge while moving from one place to another. Maybe it doesn't find a charging point, maybe it doesn't have a cord and things like that. So this may be a valuable add-on to the mobile phone. So it is, having industrial applicability as well. Now let's go for a test for novelty. This is a test for the participants, okay, in which the first example is a pen with a cap. Is it novel? No. Every pen has a cap. A process with new steps and conditions, like you change a temperature and pressure in the process. A kit comprising of two known antigens for detection of AIDS. A mobile having two screens. It's novel somehow, but not, but obvious. And what does the Patent Act say here? An invention to be patentable should not be obvious to the person having ordinary skill in the art. So the patent should have something more than what a person skilled in the art should normally expect. Now, how would you say that it is obvious or it is inventive? The first point: has the invention supplied a want? Yes, my invention, there is a want because people do suffer because of non-availability of charging points. So it is a want. A problem has long awaited solution for years. There have been charging points. Like I have I might have here. Let's see. I have a charging station here, but it's a very bulky and I have to separately carry it along. So yes, problem is awaiting a solution here. And uh, whether this is some useful addition to the stock knowledge of human being, and so on. Now I would move to the same examples that were given in the previous slide here: a pen with a cap, and made it non-obvious and inventive, a novel and an inventive thing. So a pen with a pointer and a torch. This is something which is non-obvious and this is something which is novel. So I can have a pointer in which I will teach also, it can be used. I can use it as a pen signature, and also I can have a torch within it. A process with less steps and conditions like temperature and pressure, and a new nano catalyst added to it. A kit comprising of two antigens for detection of AIDS but not known earlier, and detect both primary and secondary stage simultaneously. This is something which is novel, and this is something which is also not obvious. And mobile having touch screen when it was first launched, not now. Let's see examples of patents. A simple thing like needle, which has been around there for hundreds and hundreds of years. Can we patent that? A simple needle? No, we cannot patent a simple needle. Say that, okay, I will patent it. Why? Because nobody else has patented. But the information is already in public domain. But you can, change the needle in such a way that it would make it patentable. Obviously, you would have to go through the three things of non-obviousness, the novelty, as well as industrial applicability. You don't just take anything and say, okay, I will change it. I have a window like this. I would change the window into a triangle, and I have a rectangular window. I'll change it into a triangle, and I will patent it. No, there has to be some, applicability of it. Likewise, we said wheel. Needle is a wheel here. You do not reinvent the needle. You do not reinvent the wheel, but you modify the wheel. Here you see a needle which can be used by a surgeon, okay, for surgery, stitching back after surgery. This is a patentable needle. A singer makes machines for sewing. They design a needle in such a way that it is specific for their machine, and it adds value to the machine. This is patentable. We have the needle head which is so thin that it's difficult for elderly or somebody with eyesight problem to make the thread pass through the hole of the needle. So you design it in a such a way that it is easier to pass that thread through the hole. This thing is patentable. Why? There is a want. Okay, this is something new, this is not obvious, and it has industrial applicability. Likewise, the second example that is given here is about scissors. A scissor, which again has been used probably for hundreds and hundreds of years, can be redesigned. Like in the middle, okay, a foldable scissor. You don't need to carry a big scissor, it folds up. A scissor used for surgery. A scissor which has comb together, which can be used, for hair cutting, and so on. These are all, patentable scissors. And the industrial application says that invention is capable of being made or capable of being used in an industry. Now you say, okay, I have a proposed solution. Like there is a funny, picture given here that I've designed a trouser with, three legs in it. Well, obviously, the first thing is that it is novel. The second thing is it's non-obvious, so it passes the two things. Okay, but the third thing is, does anybody actually want it? No, nobody would want it. Why would somebody want a trouser with three legs within it? So it has a zero applicability or zero industrial applicability, even though the idea is new, even though it is novel, and even though it is non-obvious. There are some other things which may qualify the three things of novelty, non-obviousness, uh, as well as industrial applicability, but still they may not be given a patent within India. The first one is frivolous. That is, you say, I have designed a machine with 100% of efficiency, which obviously might not work because this might go against the laws of nature, or it might go against the scientific principles, wherein, some percentage of efficiency might be used, through friction and things like that. The second one is that you say that I have made a time machine. Okay, this goes against the natural laws. This cannot be patented. Something which is contrary to morality or injurious to public health, like you make a gambling machine, it cannot be patented. You make a bioweapon, it cannot be patented. uh, it has to go through, if you're dealing with some, bio related stuff, you have to check for ethics related committees and so on. Something that goes against the scientific principles like Newton's law and so on, that cannot be patented as well. uh, Naturally occurring genes, proteins, microorganisms without human intervention. Like I just mentioned, that it will come under a discovery, it will not be an invention. Now we have turmeric here. You say, okay, I have used turmeric now as a material, for beautification or something. When we know turmeric is already existing there, it's just that you have made a new form or new use of this. Just mixtures like sugar and salt are not patentable. Some methods like surgical treatments, drug dosages are not patentable as well. Well, I'll leave the last one because that might just confuse a bit, because some arrangements, like I said, pen with a torch and so on, may work. To continue with the non-patentable inventions, something related to atomic energy may not be patentable, all right? Uh, Cloning, crossbreeding, they are also not taken under patenting. In India specifically, algorithms, softwares do not come under patents. They come under what we call as copyright. Methods like cloning, crossbreeding, which are essentially biological process, may not come under this patents. However, we have taken one of the clause previously in intellectual property rights umbrella, which was under Plants Variety Act. So some things might related to plants might come under that as well. You make a movie, music, poem that cannot be patented, that is to be copyrighted, and so on. So this is something about engineering, what can be actually patented: the method or a process, the apparatus, a device, a network, means or a function, a platform, a circuit. With respect to mechanical, it can be an assembly, a method, a unit, a device, or an apparatus. Let's take a case study. I still have around 10 minutes. Okay, I'll try to see how much I can cover here. Let's take a case study of what actually has been previously patented to make you understand some things. Let's see here. A special shoe system. Okay. A system for allowing a shoe wearer to lean forwardly beyond his center of gravity by virtue of wearing a specially designed pair of shoes, which will engage with a hitch member movably projectable through a stage surface. So basically, a shoe has been designed in such a way in which a person can bend or lean forward or backward without falling down. And once the idea has been given of this spatial shoe system, it has to be given that how the shoe is, where the shoe is to be fitted, like they have mentioned it, that it will engage with a hitch member, movably projectable through the stage surface. The shoe has a specially designed heel slot which can be detachably engaged with the hitch member by simply sliding the shoe wearer foot forward, thereby engaging with the hitch member. So the first thing that has been given is a front view of a shoe, how the shoe looks like, a figure. Then we have been given a second figure in which the artist or the performer is wearing the shoe, okay, showing his, the third figure showing his center of gravity, moving while leaning forwards while wearing the shoe. Then we have the bottom of the shoe given in other figures, especially the heel of the shoe, where there has been made a specific place. The fourth figure shows the exploded bottom view, or all right, the opened view of the heel of the shoe, how it's supposed to be. And then also we have different kinds of views: the top view, the transverse sectional view, cut across view of the shoe heel, as well as the hitch view. where the shoe is supposed to be, all right, aligned. The next figure shows us the section where the shoe fits within the hitch here. Okay. So, describing with all these figures how a person can have a movable shoe, move here and there, and while moving, it just can hitch on the stage with a hitch and then bend forwards and backwards. Can anybody guess whose patent this might be? He can just reply in the chat. The clue is that the person uh, can lean forward, lean backward while performing. It has to be an artist. Exactly, Mr. Akhtar Hussain Malik. You're right. It is the patent of the late Michael J. Jackson, whose well-known, you know, uh, anti-gravity walks or the moon walks and so on, the back walks, that the lean walks he used to do, is based on this special shoe which he had designed with another Michael L. Bush, Dennis Tompkin, both from Hollywood, California. So, what was his claim? Here, the claims are given. I won't read them all, but I have just given an idea of, you know, anybody can actually um, patent a design what uh, he has made. I won't go through these claims. I don't have much of time. So, next, as a researcher, as a teacher, as a professor, would you publish or would you patent? That is the title which I have given here. Before we used to say first publish, then perish. Or publish, we used to say publish or perish. If you don't publish, you are perished. Now, the two P's have been changed to four P's. We have first patent it, then you can publish it, get the profit out of it, then you perish. So keep these four things in mind. And also, it has not to be such a complex thing as is given in the Michael Jackson shoe. It can be a very simple invention. On the slide given here at the top, you can see a guy who is having a breakfast with so many gadgets. It seems such a complex mechanism. It doesn't need to be a complex thing. It can be a very simple thing like a needle or post it. Everybody, every office, every home might have this post it. You write a note on it and you post it. And it is a patent of 3M. You cannot make it yourself. You have to get it permission. And it's so common and it's so simple, but it is having a very good industrial applicability. And what is the applicability? You say that every office in the world normally has this post it sticky pads, sticky notepads. Most of the homes would have these. In fact, kids nowadays use this post it sticky pads. Then, not just this, it can be as simple as a pin, the pin that is used for papers. Uh, Sorry, I got muted. Thank you. I'm unmuted now. Am I audible?
Yes, yes.
Okay, thank you. So, Do not publish, do not display, no posters, no journal paper, no conference paper until and unless you have taken out a patent out of it. File it. Once it's registered, you get an application number, then no problem. You can, go on and display it. You can publish it. Keep in mind that a search would be done by the patenting authority. Until that search is done, it is always advisable to keep things secret. You have given them all the details. All right, after that, whatever you say, should not be an issue. So do the picture here is mentioned, eureka, it means obviously you are telling everybody, look, I have found this thing, look, I have designed this thing. You would need to do this only once you have filed your patent, then only you can, go for it. Generally speaking, the last line is no commercial utility, don't file it. If it can help you in your academics, if it can help you to move ahead, maybe then you should think about filing it, even if it doesn't have a commercial utility. Generally, we patent something to get money out of it. And never underestimate your invention. An invention may be very simple, like the one which is given here, a paper clip. Again, you see it everywhere. A simple design like this, which is present in every corner of the world. So, you may not know the importance of your invention. You may not know the importance or the commercial value of it. So, it is advised that do not underestimate your invention. Something again may not be novel, somebody may have done it. Do a prior art search, all right? But you see that somebody has said it, the wheel is not good. So modify the wheel. Don't say I reinvented the wheel, say modified the wheel. A simple example here again is given. A plastic, triangle, something like this, is known as a pizza saver. Previously, when you used to take a pizza box, the pizza used to get stuck to the cover of it, and it was not that appeasing, it was not that tasty. So a simple invention like this helped save the pizza, and it was invented 30 years ago. Okay, so this is 3 o'clock, I believe. I have to end my presentation here. Just few things here, some common mistakes. Okay, some funding agencies which might help you in getting funds for a patent, especially the first one, that is TIFAC, TIFAC. You can Google this. NRDC, BIRAC, DCIL, UCOS, and so on. Some examples of successful patenting. There are millions and millions of dollars. Okay, simple invention. This is grandpa chair. This is a cup with a biscuit pocket, an electric plug with a hole, device to create French beard, tie with an umbrella. Thank you. All right, do we have any questions? I'll put my email in the chat box, or I'll just see if I can write here. All right, just okay. This is my email address. So if anybody has anything, okay, I have some chat here. I'll go through the chat.
Yeah, Assalamualaikum, sir.
Walaikum
Uh,
assalam. Yes, please.
I was muted, so I could not talk.
No
Uh,
issues.
so there are some questions from the participants.
In the
Okay.
chat.
Yeah, in the chat. I will read some of them.
Okay.
Uh, question from Siraj Pare. How can we actually enforce patent? Suppose you have a variety developed. How can you prevent a grower supposed to reuse a variety?
Okay. The first thing is that if you have done something, you need to file it first. Okay. You made a plant variety. It may not be a patent, but it can come under the plant, variety act. Let me just reach there. This one. It will come under PPVFR, Protection of Plant Variety and Farmers' Right Act. So you have developed it. Others cannot use it without your permission. So you can, once you have registered with it, you cannot say that this is my breed, this is my plant variety, without a proof that this is yours. How do you prove it? Obviously by registering your work with the authority. Then only, yes, you got a number, that this is my registration number. Then if you see somebody has stolen your breed, or somebody is using this without a permission, you can legally get him to the court, and you can make him pay for the act that he or she has done. Or you just warn him that you have done this thing, this is my research, you cannot steal it, pay me for what you have done. So you get a royalty after that. So he can use it, you don't have any issue, but he pays you for what he gets. Or you say, whatever earnings you have, give me a portion of that, which in which you have used my technique or my technology. So you can officially, legally stop somebody from using what you have invented if you have registered a patent or a copyright and so on. You know, it's not just about the plant variety. I give an example about Apple and Samsung. Not just that, somebody has written a poem or somebody has written a story, and you see somebody made a movie out of it, and that person says this is my copyright, goes to the court and makes him pay for that. You cannot just make a movie out of Harry Potter, J.K. Rowling's Harry Potter. You have to get the permission from J.K. Rowling, because she would have the copyright out of it. So you can protect your work with respect to these. Yes, Nisar sir.
Next question is from Dr. Muhammad Anis Ganai. Can we publish patent work in a research journal?
You first patent, then publish. Yes, no issue. In patent, you give all the specifications. Once your patent is in public domain, means that patent journal publishes it, that this is the patent number, this is the idea, this is application number. This application number is searchable in the patent search. From there you get all the details of whatever you have given. The same way, after that, it can go into a journal, it can go into a conference, but obviously first patent, then publish, not the other way around.
Okay.
And you cannot patent, because if you have published it before, you cannot patent now. Now you say, oh, I have this idea which can be patented, but I have given this in the journal, even though it's your idea, even though it's your paper in the journal, now it cannot.
So next question is from Akhtar Hussain Malik. Can we patent a work once it has been published in scientific journal?
I
I hope
think
you
I
have answered.
answered this. Yeah.
Yeah. Next question from Dr. Niyaz Mir.
But I might add one thing. You know,
Yeah.
if you have kept something in a paper, in a journal, maybe you have not given a complete description of the work in that journal, an idea. Modify it in such a way that it becomes patentable. Modify it in such a way that it becomes patentable. It's your work, so you know how to work around with it, even if it's in the journal. But obviously, it has not to be the straight thing that is already in the public domain. Yes, Nisasa. Okay, I have a question here uh, from Dr. Niyaz Mir, which says, if a person A has an idea and to execute he needs help of B, how will the patent be filed? Now, if you feel that person B uh, is equally helping person A in developing it, if you feel that person B should get the credit of developing it, so both A and B can be the inventors of the uh, the method or a device or an application. So A and B can both be inventors. And uh, typically, if you go abroad, A and B would have an equal value of invention. There's not nothing like, first author would get more points than second author in the journals. But I don't know here in India, how do they see the patent? Firstly, many would want that it should be first granted and then only. And also, they might give value to person A being the first inventor and person being B being the second inventor. But yes, if you want that this second person can be should be part of it because he has worked it, he has actually idea is yours, and idea is yours, and execution or mm, the thing was made by person B. Both A and B are inventors. Then obviously, if it's commercialized, you would have to think it that way, that you would have to pay B as well for the royalty that you get or licensing that you get. Then
Okay. So next question is from Arshad. Can you give some example of some research work which has been patented here without any product development?
research work that has been patented here without any product development. Which field? Do you mean any field?
So he has not exclusively mentioned that.
You can just patent an idea. You have not developed it, you just have an idea. You can just patent that idea. There will be thousands of patents which can be which are there, which have been just you want to ensure that nobody steals the idea, you just patent it, then you may not develop it. There have been thousands and thousands of such things, Arshid Saab, which can be just patented without actually product development. Then when you see that some company intends to develop that, you sell them this thing. Okay, you are doing this thing, you cannot do this. This is my invention. I have given this idea here, and take it. So that way, I mean, you can find thousands and thousands of such examples
Yeah.
which
Next
are
question is
patented but
from
not actually produced.
Abid Bande. Suppose we publish a book with a publishing house. Are they legally bound to pay us the royalty from their sales of the book if it is copyright of the author? How to track the quantity of the sales? That's the number of books sold.
Normally, if you go with a good publishing house like McGraw-Hill, Taylor and Francis, PHI, Wiley, and so on, Taylor and Francis, you would have to first sign an agreement with them. Okay, so in the agreement, you would sign, they would sign, and they would have a clause wherein it is specifically mentioned. Okay, that this percentage of the sales would be the royalty, okay, that the author would get. Once both of you have as well as the publisher have signed it, then they are legally bound to pay you the royalty of the book. How can you track the quantity of sales? I don't think, I mean, except the people who are selling, they would until and unless they would tell you, how would you keep the track of the number of books sold? uh, it's a difficult task, but generally when we have big publishers, they
The
would
issue.
they would tell you, because they know legally, if tomorrow they are supposed to say how much they have sold, they would have to give the details. They cannot give wrong details. So they would give the a royalty of the sales of the book to the author. And the copyright generally is taken by the publisher from you. You would have signed that you are giving you the copyright to the publisher to publish the book and sell the book, and the proceedings of the money that you get, part of it would be given to you. So you, as an author, would have given them the permission. So you are giving your right, that is the copying right, to them. So copyright may lie with the publisher itself. When you sign the agreement, it's like, you install a software and there is an agreement, you go down and you press agree. Likewise, we just sign it without realizing that there are hundreds of other things in between. And then when these things arise, they would open this legal document and say, see, you have already signed it, and it mentions that in case of this thing, in case of lesser number of copies sold, you may not get the royalty and things like that. So you would have to check with what agreement you have signed with the book author, with the publisher. And they would have only published when you would have given them the permission. If they have published without your permission, then yes, legally they are caught. Legally, you can catch them and you can ask them a very good amount to be paid, not just the royalty of the sales of the book. They have done copyright infringement, so they are supposed to pay you a hefty sum in that case. I hope that answers.
Okay, so next question from Dr. Mushtaq Ahmed Tantri. Are there any situations in which every granted patent may be allowed for others to use in case of any emergency for the larger good of the society?
Things like COVID vaccination, there can be, there can be situations in which uh, you may be forced to do certain things. Legally, you can challenge that stuff, but for a larger good of the society, like for COVID cases, you developed a COVID vaccine and you say that this is my patent, I would want money out of it. Maybe in that case, you may be allowed, but legally, again, you have 20 years of protection. If you're maintaining it for 20 years, they are bound. Yes, say that, okay, you want it, I'll send it at a cheaper rate since it's a COVID vaccination and things like that. So, yes, in case also, it's not just that you are granted and then you say that this is my grant. uh, if somebody says that even after grant that no, it's supposed to be mine, we call that as post grant opposition. It can happen in which you would have to fight against that. But your question is particularly a general question. In case of emergency, maybe legally you are sound, you have a patent already. Yes, for a larger good of the society, if you yourself license it, is a different question. If you are forced to, I don't know, it has to be legally seen. uh, but then for 20 years, a light bulb was somebody's patent for 20 years. You had, even though it could light up whole of the world, it was Edison's patent. I don't know what he had done, how he had taken the royalty, but then seeing the applicability of it, that it could light up whole of the world, it is a larger good as well. But somebody's invention, you need to pay for it. It's
Sir,
like
my
piracy.
question,
It's like
Next,
piracy. You say,
there are some
uh,
questions. Angel.
sir, if you may please,
In case
basically, my point was that, for example, a particular company invents a drug and they patent it. However, take for example a COVID vaccine, but they don't have a sufficient infrastructure to meet the requirement of the public, and the mortality rate of that is that. Is there then any rule where the government or the patent they can set up get in and allow other to manufacture that drug?
actually, you have to first see what is a patent. Patent is a protection which means that commercially it cannot be made, used, distributed, imported, sold, and you are forcing the same thing. Do
Exactly.
you get my point?
Yes, yes.
Patent is a right which has been given to you so that nobody else can do this thing, and you are now saying that for the betterment of the world, you force the things on it. So for
Uh,
20 years, you are, I think, in my
that's what I
opinion, you
meant
cannot
to
force
clarify.
things.
Okay, I wanted to clarify that. Is it rules?
next
So
question is from
Yeah,
SM
basically,
Vidyarthini.
sorry. Basically, patent protection is saving these things, what you are actually saying,
okay,
that you have been not forced to do this. You
Okay,
say, okay, I don't want the good of the society, I won't sell it.
okay.
Or pay me this much of money, then only I will sell it. Somebody would say, okay, you are asking billions of dollars for it. Say, yes, if you can pay me, I'll license it because
Okay.
I have worked hard for it.
Okay.
Okay, sir. Next question from SM Zubair Saab. In case two people working independently in their respective countries do something worth patenting, whom among them would get the patent if both apply for it at the same time?
It would depend upon who would patent first. I mean, whose registration is done at first.
Mm.
Now, let's say somebody is working here in India and somebody is working in United States. Both are working on the same thing, and both of them file it. Now, what are the chances that both of them file the patent on 6th of January 2021 at 3:20 p.m.? Okay, what are the chances? Chances may be less. Somebody might, okay, both of them file at the same time, same day, but one of them would be at 3 p.m., another would be at 3:15 p.m. Obviously, the one who has filed at 3 p.m. would get first, then the one at 3:20 p.m. And
Okay.
you have to understand one thing. Now you will see that, okay, I will patent in India and let him patent it in America. But when you file it in India, you get an application number. There would be a patent search done by the Indian authorities. They would see whether this invention has been already patented somewhere or not. And when they make a search, they will find that this is somebody else has done in this in America. So uh, your work cannot be patented. But there is one thing here. It's a territorial right. So somebody in United States can force other person in United States not to make, not to sell, not to commercialize the thing. But he cannot force from there in India and say that this cannot be done here. This can be done here. You can't say it's infringement. But if you import that technology here and start selling that technology here, that is infringement. Yes.
If there are some other questions from the participants, please. Yeah. Are there some other questions?
निसार साहब मेरी आवाज आ रही है?
Yeah, yeah,
Yes.
yeah.
जी जी, एक क्वेश्चन था मेरा। जस्टिस साहब, शुक्रिया पहले आपके बहुत अच्छे लेक्चर के लिए।
Thank
जस्टिस
you,
साहब,
sir.
आप सुन रहे हैं?
Yes, yes, please. Thank
जी,
you.
मुझे आपसे एक सॉर्ट ऑफ ए पर्सनल क्वेश्चन है। मैंने कोई जैसे मटेरियल लिया हुआ बाहर की यूनिवर्सिटी से, समझिए आपके बायोलॉजिकल मटेरियल, which was patented by them, and now I have a material transfer agreement with them,
Okay.
say like 5 years back. As of today, now the patent, their 20-year patent protection is gone.
Okay.
Am I still allowed to follow the material transfer conditions of material transfer agreement or not?
This depends ki what is actually written in the agreement. If material
अच्छा,
transfer is nothing related to patent infringement, then it's a separate thing altogether. If it's
हम्म,
something related to patent, patent protection is gone. But
हम्म,
what you have written in agreement may not be related to patent agreements. आपको मेरी बात समझ आई? It may not be that they are saying that you cannot commercialize because we have patented it. They might have
हम्म।
written that you cannot at all commercialize it
नहीं,
beyond
मटेरियल
any
ट्रांसफर एग्रीमेंट
specific.
में जो मेन चीज था वो ये था कि इफ समथिंग commercially be viable comes from this study, then you will have to share with them that university also.
So if you have legally, given that you cannot do this thing, it's not. Have they given authority of using this patent to you?
Not exactly the patent, they have given me it for a personal use, for a personal project. Say like it
Hmm.
is a DNA vector, for example.
Okay.
It's a DNA vector which I am allowed to use for a particular study. So that is under the material transfer agreement. I have given the title of the study also. Now, me from last 3 years, their patent is actually expired. Am I,
Mhm.
if I have to want to use this now for a different project, have I to still inform them?
Like I said, it will depend upon the legal document that you have signed. It's not. It's not like a simple case that I have a light bulb. Now I don't have to ask permission from Edison to use the light bulb in whether I use this light bulb for home or an office. Whether I use it for lighting up a street or something. So that one is, a very simple way. You have gone into a legal binding with another institute. You have
because of
signed
MTA.
something. Yes, you have signed a MOU or something. It may be beyond what is written in the Patent Act. Do you
Okay.
get me? A lawyer can
Yes.
explain it in a better way, because this is beyond the scope of something that is, you know, patentable or not patentable, or infringement of patent. You are saying
Mm-hmm.
that anything that comes out of it, you will be part of it commercially, or a patent, if you intend to do patent and you have used their material. So this has to be seen from a legal angle.
Mm-hmm. Okay, sir. Thank you.
And you have to realize that patent war is not something that is very new.
Mm-hmm.
Till now, like we say, if I ask you a question, let me think about it. Yes, if I tell you that who invented the telephone.
Mm. Uh, that Ranginton or what was his name? Something like that.
Normally we
Graham
say,
Bell.
Marconi was the one who invented radio, right? Let's say
Yeah.
radio, right? If I
Yeah.
ask anybody who invented radio, Marconi. But
Marconi.
there is still, debate. There is still legal issues, wherein they say that Marconi was not the person who actually made radio. It was Tesla, Nikola Tesla, who
Mm-hmm.
who actually had made the radio, and
Mm.
who then actually had given that in 1884 how these things would work. But one, Marconi being Italian, and I think Tesla, not sure, maybe Tesla was American. Uh, I'm not exactly sure where it was, and they still had this patent fight of who actually did this. Tesla, you can Google this Tesla Marconi patent war.
Mm.
Who actually
Okay.
was the inventor of radio?
Okay, another small query regarding these biological materials. When you were explaining initially between the invention and discovery,
Yes.
you said, for example, the things which are already there are come under discovery. They cannot be patented.
Hmm.
I don't know if you have an idea. In biology, what confuses me is once they had this with the WTO, other things that the biological materials cannot be patented, such as, for example, DNA sequencing or gene sequencing. But at the same time, for example, many cancer cell lines are patented. Many monoclonal antibodies are patented when they were already in the system. That is, in one
They,
definition, that is
they
nothing new.
might they might have used some kind of tool to actually find out. I have a slide patenting about life sciencing. I'll just can you see the screen?
Yes, sir.
I have this. I had added this for one of my presentations, which I gave it to life sciences department.
Please go there. I can take a snapshot of that.
Okay, I will just go to that point. After that, I had added those slides there. So, so one thing is here: anything under the sun made by sun can be patented. But depending upon Indian patent law and American patent law, they are different. I'll give an example. I'm being a computer scientist.
जी
I can patent a software like you have PDF, Acrobat's PDF.
जी
I can patent this in United States. There is some noise coming.
सर
Okay,
ये पता नहीं किसी का
it's
माइक्रोफोन ऑन
fine,
है
fine now. Okay, clear हो गया. मैं आपको एग्जांपल देता हूँ. आई कैन पेटेंट पीडीएफ जो एक्रोबैट ने बनाया है सॉफ्टवेयर. इट इज पेटेंटेड. जब आप इसकी इंस्ट्रक्शंस देखेंगे या हेल्प देखेंगे या अबाउट देखेंगे, इट्स पेटेंट दिस इन यूनाइटेड स्टेट्स. वेयर इन इंडिया इट कैन नॉट बी पेटेंटेड बिकॉज it comes under copyright. So these things might vary. Here are some slides.
जी सर जैसे आपके स्लाइड पे है फॉर एग्जांपल एंटीबॉडीज
Yes,
antibody is a natural thing how it is allowed to be patented then
let me come to this one. Okay, look at this Indian patent scenario with respect to biotechnology and related.
Hmm.
Method of treatment is not patentable. a plant or animal in whole or a part thereof other than a microorganism but including seeds, varieties, species, and essentially biological processes for production or propagation of plants and animals is not patentable. It will come under that Plants Variety Act that I had mentioned. New form of known substances or new use of known substances or new property of known substance are all non-patentable invention. You can see here different sections which mentions here. Like you said, patents section 3C says provisions are related to the discovery of any living thing or non-living substances occurring in nature. So what you are saying here is this thing. Have a look at this in biotechnology, life science related subject. Other than the novelty, the obviousness, the industrial applicability, you have to see its morality, like bioweapons and stuff, its enablement, and its inventive step. So it excludes discovery of living things occurring in nature, like you were just now mentioning.
Sir, but antibodies are patentable, as we had seen the BD, Pharmangen, and many other companies are there.
In
Once
India,
you are doing any modification in the natural antibody, because you are doing specific. Yes,
modification. That is what I'm saying.
yes. So
It's not.
antibodies, after doing modification, they are patentable, because
Yes,
it's
yes,
why that on which these Pharmangen and BD and other Merck and Elmer companies thrive on. This is a
yes,
billion
but
dollar trade.
yes, but there are two things within it. The first thing that you mentioned is the companies are American, right?
See,
So
in India, we have Biocon. Kiran Mujumdar is running that company from Bangalore. Kiran Mujumdar is the Biocon owner, and
okay,
she's also patenting most of these antibodies, which are hybridomas. Through hybridoma technology, they
yes,
are creating them, selling them in the market.
but they are creating them, right? It's
Yes,
not
yes, exactly,
something. It's not something that is already available in nature. Number
exactly,
one.
exactly.
So if you see at this slide, anything
Yeah,
under the sun made by a man. This is in US. You can easily get a patent as compared to the laws which are in India. But
Exactly, sir.
like you yourself said that if something is modified, it's not something which is easily available in nature. It's not something which is already there.
Sir, if you don't mind, can you share your this presentation?
Sure, sure, sure.
Would be nice. Thank you.
My pleasure.
Okay, if there are some other questions from the participants. Okay, if there are no questions
Just
from the
just a one more query, sir. It might sound a sort of a stupid question. If
Uh,
a
no-
patent
Nothing is stupid. Please go ahead.
if a patent is say like granted in one country, say like US,
Yes,
and if there were you asked like and if there that is not then again registered under this, you said the Geneva, that body where there are only 35 countries which are signatories to that. Does
yes,
that mean if I move to outside these 35 countries, I can copy it or do work with
yes,
it?
yes, yes, yes.
That means
By
okay,
law, yes. By law, you cannot force it.
you cannot force it.
Yes, yes. If something is made in, India, it is
Mhm.
patented in India. In United States, you cannot force the same thing. You have to realize. That's why you see Chinese things are everywhere.
Chinese
But
things are
yeah,
But there is sir one thing of reverse processing, as NK Gujar did in case of the retroviral therapies, which was available to the African countries for $5,000 in case of HIV/AIDS retroviral therapies. NK Gujar at NCCS did that by reverse processing or back processing, what we say. If you are doing back processing, otherwise the companies will sue you. If the patent is approved by the
yes,
Americans and you are
yes.
trying to copy that in India without taking permission from that company, they will sue you in the International Court of Justice or any court of the justice.
No, you have to realize one thing. Patents are territorial rights. That was my first slide. Territorial rights means that it is only in a specific territory that I can cover it. Yes, I cannot, once I make something here, something was patent in America, I cannot sell the same thing to America then.
But
Because
sir,
I can patent it
one is
there.
a big multinational company gets a patent in US, automatically the across the globe had got the patents for the same thing. It's what the big pharma companies and other things are
No,
doing.
no. They go to PCT. They have to individually protect their patent in each and every country. It's a
That's what I am sir
territorial
saying. One is that don't
Yes.
America, they automatically do the same thing in
no,
almost across the
au-
globe.
automatically won't happen. They would have to
They
patent.
have they are taking one is the get a patent is granted to a company, big multinational company, and that had its footprints across the globe. First thing what they do before going to the America, that then apply the for the patent and other copyrights
Yes,
in other
yes,
countries.
yes. Yeah, that is what is territorial, right? That you will cover each and every territory. You go, you made it in India, go and patent it in America, patent it in UK. You patent in maximum countries where you feel that this may be copied. You know, you might not go to some African country where you feel that this may not be copied. Even if that African country copies it, then tries to sell it across these countries, you can legally catch them up.
Thank
But
you,
yes,
sir.
but
Thank
yes,
you.
one thing is there. You make something, and then in China, a small house would replicate the same thing. It's difficult to get them, catch
Yes,
them legally.
exactly, sir.
Justice Saab, very informative talk. I want to ask that why we have very less patents in J&K. That's what my question was basically. Do we think it is basically related with engineering field and or there is very less scope in biological or other fields mostly which we do research here?
Sir, it's a very good question. Why we don't, have that many patents? I believe the first thing is that we do not know what is patenting. ग्रास रूट लेवल पे आप देखिए किसी स्कूल में कहीं आपको लगता है कि ये चीजें बताती हैं कि पेटेंट करो कम से कम
No, no, no.
मैंने तो कहीं नहीं देखा है किसी स्कूल में ग्रास रूट लेवल पे ये बताया जाए कि मतलब आप पेटेंट करो आप ये चीजें बताओ सो वी लैक दिस नॉलेज नॉट इवन अब आप छोड़िए अब स्कूल्स का कॉलेजेस का ही देखिए
Sir,
यू नो
at university level, we don't have a patent office even in the University of Kashmir or any other
I
university.
haven't seen
Yes,
anywhere. I haven't seen.
yes,
I was
that's
in
what my
When it is
point
not
was.
in the university, how can we expect in school?
I was in MIT for 13 years. There I have not seen an intellectual property right IPR cell which should have been part of every place. जैसे आपको कुछ प्रॉब्लम डिफिकल्टी है या आइडिया है आप किसके पास जाएंगे ये बोलने के लिए आप किसको बताएंगे क्या फॉर्म फिल करना है who would guide you who would pay the fees so we
And
lack these facilities obviously ये खुद ही तो नहीं आएंगी ये चीजें until unless these things are there then only these things would happen at least
I
hand
and
holding की तो बहुत जरूरत है
we think that mostly we cannot patent. मतलब, just like in biological science, we think it's not for us. Maybe
no
it is
it's
for.
not for
That's
engineering
also.
only it's for everybody it's for
That's.
every field
I think that is also na,
आप अगर
that's a lack of
food
awareness. I can say that how we can patent and what we can
exactly
basically patent.
exactly awareness is lacking आप छोड़िए बायोटेक्नोलॉजी आप छोड़िए इंजीनियरिंग आप फूड टेक्नोलॉजी में ही देखिए आपको देखिए कितनी स्कोप है
Thank you, Jess.
my pleasure my pleasure
Okay, I hope there are no more questions. Uh,
there is a question from Sayar Ahmed who says is there any sort of corruption in granting patents there are two things. One thing is that you pay somebody and tell them, okay, grant me a patent, which I believe may not happen because it's a government organization in the sense that they would do a thorough review of it. But yes, I won't say that there's a corruption, but if you pay a good lawyer for fighting against for fighting for your patent lawyers can do wonders in that case they will ensure that you get a patent out of it that can happen which may not be corruption
okay, so on behalf of HRDC University of Kashmir and on behalf of the participants, we would like to thank Professor Dr. Muhammad Ihsan Chisti, for such an enlightening and thoughtful talk, and then for the discussion that we had at the end. It was really one of the lectures which had very thorough discussions on the things which are directly related to the patent filing. Thank you, sir. Thank you.
Thank you. It was my pleasure. I would thank the organizers, especially Professor Gears, for letting me speak on this occasion. I think I would like to thank participants also for listening to me. I mean, it's difficult to have online lectures, but they have been listening to it, and we had a wonderful discussion after the talk. Thank you so much.
Thank you a lot, sir. We will be waiting for your presentation.
Sure, sure.
So now I would like to invite Dr. Ifat Bashir for her presentation. Dr. Ifat Bashir. I also request Dr. Kausar Wani to be ready for the presentation after Ifat Bashir.
Assalamu alaikum. Is this visible?
Yeah, it's visible.
Assalamu alaikum and a very good afternoon to all of you. Myself, Dr. Ifat Bashir, Assistant Professor in Sericulture, GDC Boys, Sopor. So here I am going to put forward my presentation titled Journey from Minute Egg to Silk Sari. Well, at the outset, let me first explain what sericulture means. The rearing of silkworms for the production of raw silk is called as sericulture. How this silk was discovered? Well, it's an interesting story and dates back to 2700 BC, when a queen, namely Chinese queen, she was actually, and her name was Ziling Shi. She was sitting in her garden under a mulberry tree, enjoying her cup of tea, and suddenly an oval structure fell into her warm cup of tea. When she wanted to take this oval structure, later called as cocoon, she wanted to take this structure out of her warm cup of tea. To her utter surprise, a thread-like structure stuck to her fingers. And this is how silk was discovered. Now, what's the eating habit? What's the food habit of the silkworm? Silkworm is monophagous. That's, it feeds only on mulberry because mulberry contains a phagostimulant called as morine, which attracts the silkworm towards it. So sericulture is impossible without moriculture, that's the cultivation of mulberry plants. This is the life cycle of silkworm. Silkworm is a lepidopteran insect and is holometabolous. That's, it is all the 4 stages of life cycle: egg stage, larval stage, pupal stage, and the adult stage or the moth stage. In case of silkworm, the pupa is enclosed in a protective case called as cocoon. So how this cocoon is spun by the silkworm? Silkworm has a pair of modified salivary glands called as silk glands. On the 27th day of larval stage, a silkworm is ready to spin its cocoon. So what are all the changes that take place before the onset of cocoon spinning? The first and the foremost change is the cessation of feeding. That is, the silkworm larvae stop to feed. They do not more get attracted to the feed, that's the mulberry leaves. Then their body turns translucent. There is shrinkage in the larval size. Then a secretion takes place through the mouth, which on contact with air gets hardened, and that's what silk is. So to spin a single cocoon, a silkworm larva moves its head in the form of the figure 8. That is, a single cocoon is spent when the silkworm moves its head in the form of figure 8 3 lakh times. So ultimately, this cocoon, this is needed to produce the silk. there is ultimate sacrifice for the beautification of humankind. Well, to look beautiful, we have to kill those pupae inside the cocoons so that we can get a continuous silk thread. How these pupae are killed? Pupae inside the cocoons are killed by sun drying or by exposure to hot steam. Then the cocoons are boiled, the silk thread is unwound carefully, and a single cocoon, when a thread is unwound from it, a single cocoon gives a silk thread of 1000 to 1200 meters in length. So let us see the height of sacrifice. For making a single silk tie, we have to use 110 cocoons. That means we are killing an equal number of pupae inside the cocoons. Likewise, for a silk blouse, we need 630 cocoons. For making a silk shirt, we have to kill 1000 pupae. That means we need 1000 cocoons. And for a silk sari, we have to kill 10,000 pupae inside the 10,000 cocoons. And that's how we look beautiful. We wear a beautiful attire that is silk, but we do not know how much sacrifice those silkworms have to make for the beautification of humankind. Thank you.
So thank you for your nice lecture. Uh, I would like to invite Dr. Kausar Wani for her presentation.
Hello, am I audible?
Yes, yes.
Assalamu alaikum, everyone. The topic that I have chosen for today's presentation is pollination. Pollination is the part of the process of sexual reproduction in plants, wherein the plants set seeds which further become the propagules of their perpetuation. The units for this reproduction in plants are the pollen grains and the egg inside this ovary. The male reproductive, all both the male as well as the female reproductive parts of the plant are there in the pollen grains, are inside the anthers, and it is like here they release the pollen grains which have to be transported or reach the stigma, and then they pass down the style to reach the egg where they can fertilize the egg present inside it. When they once reach to the stigma of the flower, and this transfer of the pollen grains from anther to the stigma is called as pollination. There are two main categories of pollination, that is the self-pollination and cross-pollination. Self-pollination means when the pollen grains of this same flower fertilize or pollinate the female reproductive parts, that is the stigma of the same. When the pollen grains transfer or travel across to pollinate the stigma of any other flower, this is called as cross-pollination. So self-pollination is the transfer of pollen grains from we have got the pollen grains or to any other flower with present on the same plant. Accordingly, self-pollination is autogamy and geitonogamy. This autogamy or self-pollination naturally once it pollinates the stigma of the same flower, so we can say that it occurs by two main methods. One is the homogamy and other is the cleistogamy. So that these are the two kinds of the adaptations that flower has or in a plant. Homogamy means when the anthers and stigma, they have the same size, they have the same. So all these conditions favor that the pollen grains reach to the stigma of the flower. And cleistogamy is another this adaptation for self-pollination in the plants. In the cleistogamous flowers, these are the flowers which never open. And inside the flower, as well as female reproductive organs are present, and the flower bud never opens. There is no other chance that automatically the anthers dehisce and release its pollen grains on the stigma of the female reproductive. On the other hand, is the condition when the pollen grains of a flower pollinate the stigma of any other flower but present on the same plant. So it is another kind of the self-pollination. Pollens do not or to go any other plant. Here they pollinate any other flower but present on the same plant. Now we come to the contrivances, or you can say the adaptations for the self-pollination. There are two main adaptations. They are homogamy and cleistogamy. Homogamy is the maturation of the sex organs of the flower and the egg-bearing ovary, stigma, and style at the same time. Once they mature together and favors the self-pollination automatically. On the other hand, cleistogamy, as I told you, that the flower never takes the chance to open. Once it never opens, automatically. What are the advantages of the self-pollination? Since during the self-pollination, the pollen grains do not have to depend on any other or water, or any agency for that reason to deliver the pollen. Therefore, it ensures the greater reliability to travel across a distance. However, self-pollination or self-fertilization has a disadvantage that it is an extreme or inbreeding depression in the plants. Now we come to the cross-pollination. It is the transfer of pollen grains from the anthers of a flower to the stigma of any other flower. However, has a major advantage that it gives the genetic recombination as the gametes of two definitely do the genes. Now, there are certain, there are certain advantages as well. Say, how can we say that a flower has both the male reproductive organs as well as the female reproductive part in it? Cell of the plant goes for the cross-pollination. It is because of some of the very important adaptations that the flower has. These adaptations, stability, or you can say the self-incompatibility of the flower, dichogamy, hercogamy, and is it? It is this kind of the adaptation is genetically controlled. That is the pollen grains. See, they although one second. on the stigma of the same flower, but it is unable to germinate on it. It is genetically as the genus, they don't let it to germinate on it by the release of some proteinaceous substances or the gene release. Even if they germinate, as you can see here, even if they germinate of the same plant. And next is the uh, match both the sex organs, that is the pollen grains as well as the egg. Both are fertile. Both are the fertile. What happens, still it doesn't favor the self pollination, is that they mature at two different stages. Sometimes the male parts mature earlier than the female parts. By the time the male reproductive parts mature, the female has already female matures and the male reproductive parts have dehisced and they have released the pollen grains. So they don't reach to the same time of their maturity. If male reproductive parts mature, is called as the protandrous condition. But if the female reproductive parts mature first, then the males, here is one more adaptation that favors the cross-pollination that favors the cross-pollination is hercogamy. Here, see in these flowers, since the reproductive parts parts of a plant are contained in a flower, see in these flowers, there are both are present. In the first image, this the pink, and this is the pink colored part, which is the of the anthers, that once the pollen grains are released by the anthers, they do not reach up to the level of the stigma and they are lost down to the level of the stigma and do not ensure the the self pollination of the stigma is fertilized or pollinated by the pollen from any other plant, not by its own flower. Condition where hercogamy is absent, that is the pollen grains and the stigma style are at the same level and they can easily fertilize its own female reproductive cells. And that favors the cross-pollination in the plants is the heterostyly. Style is the that receives, that transfers the pollen grain down to the egg. See, in the first flower, it has long style, while as in the other, it has a short style. The first, that long styled flower has it ensures such condition ensures the cross pollination only in the flowers and discards the tendency of self pollination to occur. Now, what are the different agents and the types of the cross pollination? That the agents which ensure the cross pollination in the plants. There are abiotic agents as well as that is the transfer of the pollen grains by the wind. Hydrophily, as name indicates, it is the transfer of the pollen grains by water. By insects, ornithophily by birds, and the chiropterophily by bats. And then one more important, the artificial pollination by hybridization techniques, that in the modern days we go for the artificial hybridization finest bursts to release the pollen grains, and these pollen grains are taken away by the wind, which is to pollinate the female cones or the female flowers of these pinus trees. Some this hydrophily, that is the pollination that occurs by the inside the water, that as the grains along with it, and they take these pollen grains to the female flowers to ensure the cross pollination. Now this is the pollination bees. As they visit different flowers to suck the nectar, while they're visiting, they rub their body along the and thereby they can pollinate, reaching to the other flower, they can pollinate stigma of those flowers. In this way, they ensure they cross Pteropterophily, that is the pollination by the bats. This is a bat that visits to the flowers to suck juice from it, and definitely it will go and visit some other flowers, taking the pollen grains from the other flowers, and thus ensuring the cross pollination in the flowers and the plants. And this is the last, that is the artificial pollination by hybridization techniques. And we want to incorporate the traits or the genes of one into the other, and then accumulate those genes there. We select the pollen. The picture shows that this person has been artificially pollinating the female rice, and then it is a long research, and then after that ensuring the pollination, then fertilization, and then we can finally get the desired plant. And these are the different types of the pollinations. Here we complete the presentation. Thank you.
Thank you. Thank you, Kausar Parveen, ma'am, for your nice presentation.
Thank
There
you.
are some questions from the participants.
Yeah, sure.
I think it's already 4 and no one wants to be here for the longer time. So we would like to thank Dr. Kausar Parveen for her nice talk. Thank you. Thank you. We will be concluding the session right now.
Thank you.
Thank you. Thank you, Dr. Raja Nisar Ali Saab,
Yes,
for
Gir sir.
moderating the. Yeah, I have just now joined. Just now I have joined.
Thank you, sir.
I have just now. Yeah, I had my own online lecture today, so I just finished it. It was to be delivered for Naipur Mohali, and I joined back. I even attended the presentation by Dr. Kausar Parveen. Very nice presentation on pollination. Thank you very much for moderating the session. Thanks to all, you have done it very well. Thanks to the speakers of the day, as well as to the presenters and rapporteur, as well as moderator. So we hope we'll be able to continue. I think the power supply has been restored in most of the areas. Thankfully, we will be able, tomorrow we have a session by Dr. Muhammad Sultan Khuru Saab on research. There was a lot of demand from the participants that there should be the session on research. So I have requested Professor M.S. Khuru Saab to focus only on research objectives, research ordeals, research, how exactly research fundamentals, the research has to be done. And then he will be narrating some of his own lifetime experiences. I'm sure it will be a very nice session to attend tomorrow morning. And in the afternoon, we have a session by Professor Manzoor Ahmad Malik Saab of the Department of Physics. Meanwhile, I would request the participants to volunteer who is going to, as per the list which I have posted in the WhatsApp group, who is going to be the moderator for tomorrow's session, and who is going to present as per the list, please come forward and give me your names so that we can plan it well in advance.
Sir, I will
So
be the
thanks to
rapporteur
all of you.
for the second
Yeah.
session.
Yeah, what? Sorry?
I am Rajan, sir. I will be rapporteur for second session.
Okay, you will be rapporteur for the second session. And who will be the moderator for the morning session? Well, I will check it out from the list, then I'll put it in the WhatsApp group. And
Yes, sir.
the presenters, names of presenters also, I'll put it in the WhatsApp group. So we'll proceed accordingly. Tomorrow we'll be back at 10:30. So we'll see you at 10:30. We'll start with participant presentations as usual. Then Dr. MS Kuru will start at 11 o'clock. So hopefully you will recharge all your gadgets, and we'll be in a position to join back tomorrow at 10:30. Allah Hafiz. Bye for now.
Assalamu alaikum.